This case requires us to examine two legal issues at the same time. First, whether statutory rape is a strict liability crime in Maryland. For that, we have to dive into the statute. Second, if it is a strict liability crime, what's the legal impact? Defendant was a 20-year-old with an IQ of 52 who had sexual intercourse with a 13-year-old girl, Erica. How do we know they had sexual intercourse? Because sometimes you actually don't know. They know because Erica, the 13-year-old, got pregnant. And that's a common way to discover statutory rape. In Maryland, if we look at the statute, it's second-degree rape to have sexual intercourse with someone under 14 where the defendant is more than 4 years older. Erica's 13, Garnett is 20. Now, Raymond, Garnett, wanted to introduce the fact that he didn't know that Erica was under 14 years old. She had told him she was 16. Her friends told him she was 16. In fact, she looks 16. And I'll even add in here that his IQ level was below average. With all those facts, should he be able to introduce his mistake about her age as a defense? In effect, he's saying, please don't convict me, because my mistake about her age negates my culpability. It negates my blameworthiness. But here's the deal. He can introduce this mistake only if there's a mens rea requirement built into statutory rape. If there's a mens rea requirement built into statutory rape, then he's got a defense to rebut it. But if there's no mens rea requirement in the statute, then there's nothing to rebut. Then it's irrelevant what he thought. Let's look at the Maryland Code. States sometimes include all forms of sexual assault in one statute, and some states separate out statutory rape into a different provision. That's because it wants to send a message that statutory rape is different. Maryland is one of those states that includes different types of sexual assault in one code. Section 1 is about forcible rape. That was the common law version of rape. Section 2 focuses on a particular type of infirmed victim that could end up qualifying as rape. And Section 3 is about age. To Maryland, all three deserve to be in the same statute. The section that applies for our purposes is subsection 3. There, prosecution must prove that there was a victim who's under 14 who had sexual intercourse with someone at least 4 years older. The question here is whether this section also includes the requirement that the defendant must have a mens rea to be found guilty. If I look at the words of this section, do I see a mens rea? The trial court didn't allow his defense in because the trial court said it was irrelevant if he was mistaken. It was irrelevant if Erica fooled him because this crime is a strict liability crime. The trial court looked at the section, didn't see a criminal mens rea, and made that determination. How can we square the idea of having blameworthiness with only an actus reus and no mens rea? These states would say that there are several reasons to make the crime strict liability. First, it protects the underage person. Often the female won't have to go to court or be judged by how old she looks or what she said. The state doesn't want Erica to have to come into court to be cross-examined by Raymond's lawyer. Second, these states say that strict liability is legitimate because actors should always assume the risk that if they had sex conducted outside of wedlock, perhaps that person is underage. If it weren't a strict liability crime, if there were a requirement of mens rea, then defendant would be able to claim what we call the affirmative defense of mistake of age. Defendant would be able to say, I didn't intend to have sex with someone underage because I had a reasonable belief she was over the age of consent. The mistake's got to be honest. It's got to be reasonable for the defense to apply. If our defendant drops off the young lady at middle school, defendant's not going to be able to come into court and say, oh, I thought she was 16. It's got to be an honest and reasonable belief. I want to examine a case that's mentioned in Garnett. The name of the case is People versus Hernandez. It's out of California. This was the first time that statutory rape anywhere in the country was turned into what we call a true crime, a crime that requires both an act and a mental state. And it was the perfect case to change the law, poster child in fact. In California, the age of consent is 18. And here, the victim was 17 years and 9 months old, right at the 18-year-old line. And she, in fact, looked 18. She said she was 18. the defendant argued that basic principles of criminal law, as codified in certain sections of the California Penal Code, require a mens rea for any true crime, any serious crime. In Hernandez, the California Supreme Court said, you know what, this makes sense. Just recently, we overturned bigamy as a strict liability crime. There, if a defendant were married at the same time to two different people, defendant should have been able to come into court and say, I didn't intend that. I was honest and reasonable in my belief that I'd gotten a divorce or that my first marriage didn't count. California Supreme Court stated that there's a reasonable evidence that the victim's the age of consent, then defendant has relieved his assumption of the risk that he was intending to have sex with somebody underage, or he'd assumed the risk he was having sex with somebody underage. He should be able to come into court and present the defense of mistake of age. He should be able to say, I thought she was of age. Not only did I think she was of age, but my belief was reasonable. Others would have thought so too, and therefore I'm not blameworthy. So now back to the Maryland statute. Which one is this statute? A strict liability statute, which means the defendant can't offer a defense? Or is it a statute that includes a mens rea, like California adopted, that would offer a defense of mistake of age? In order to interpret a statute, a court must always look to the code itself, the plain language of the code section, and to the legislative intent behind its enactment. Remember, the legislature makes the law, the courts are there to interpret it. The problem here is that this subsection is silent. It doesn't specifically say that the crime's a strict liability crime, but it doesn't say it has a mens rea. So since there's legislative silence here, the court had to figure it out. Here the court decides that silence means that statutory rape in Maryland is a strict liability offense. What it did was it looked at subsection 2. Let's look at it right now. It looked at subsection 2 to arrive at that decision. The majority said that the legislature knew how to include a mens rea in the statute if it wanted to. Subsection 2 has a mens rea built into it. That mens rea is the other person knows or reasonably should know. There we go, that's the mens rea. That means that the only elements the prosecution must prove in subsection 3 are that Raymond had sexual intercourse with Erica, that Erica was under the age of 14, and that Raymond was more than 4 years older than her. I want you to look at the opinion itself. Under the heading of Drafting 101, the majority opinion spends a good deal of time in Part 3 of the opinion on scholars and states that make statutory rape a mens rea crime and allow a mistake of age defense. Why do you think that the court does that? Why would it give so much airtime to other states? That's the majority's way of suggesting to the legislature that it changed the law. It seems as though the majority is sympathetic to the notion that a serious crime such as this one should have a mens rea, but the majority's position on its role as a court is it can't do it. Majority argues that's not what we are supposed to do. That's the purpose for the legislature. The legislature makes the law, the court interprets it. If a change is going to be made, the majority says the legislature has to be the one to do it. Perhaps all of these case illustrations were attempts to have the legislature pay heed, pay attention, and change subsection 3 on its own. But if I fast forward, let me tell you, it never happened. And it never happened no matter who became the Chief Justice and no matter which legislatures changed. I want to focus on 2 dissents out of this case, one by Judge Eldridge and one by Judge Bell. Judge Eldridge agrees that the legislature took out the mens rea in subsection 3. So in that sense, the judge agrees with the majority opinion. Assumption of the risk inherent in statutory rape necessarily means a mens rea. The mens rea of knowledge, the judge argues. And Judge Eldridge gives 2 examples to suggest that it would make no sense to have a completely strict liability offense in statutory rape. One involves a severely mentally challenged person, the other a passed out 20-year-old. In either situation, without knowledge, the judge argues, defendant shouldn't be convicted. The dissent by Judge Bell attacks a different aspect of this case. The judge agrees that this is what the legislature intended. It did intend for statutory rape to be a strict liability crime. But then the judge goes on and says, you know what? Not every action by a legislature is beyond judicial reach. Not every action is going to be okay just because the legislature said so. And to Judge Bell, it's not okay to eliminate something so fundamental from the state's burden as a criminal mens rea. Judge Bell said it offends the principles of decency to have a crime that carries with it such a steep penalty and not require a mens rea. It offends sensibilities and decency not to allow Raymond Garnett to come into court and say, I didn't intend to have sex with somebody under the age of 16. I had a reasonable belief that she was 16. Strict liability crime relieves improperly, according to the judge, the state's burden to prove all the elements of a crime. So to recap, in this part of our lecture, we looked at strict liability crimes, and specifically we zeroed in on statutory rape, which today remains the only serious crime that is a strict liability offense. A strict liability crime means that the only elements a prosecution has to prove are the elements of the actus reus. And when it comes to statutory rape, that would mean proving sexual intercourse with a person under a certain age presumed incapable of consenting.